Welcome back to the Rant Press, the news division of the Read It Rant podcast, where we bring the same no sugarcoating approach to the headlines that we bring to every other form of media that we consume. I'm your host, Tony, and tonight we're going to do something different. We're not going to talk about what, TikTok thinks happened. We're not going to talk about Facebook comments. And we're not going to decide this case based on whether we personally sympathize with Lindsay Clancy or despise her. Tonight we're going to talk about the evidence that's presented in court. Because after 21 days of testimony, dozens upon dozens of witnesses, competing psychiatric experts, medical records, digital evidence, family testimony, and some extraordinarily difficult testimony concerning the deaths of these three children. The evidentiary phase of the Commonwealth of Massachusetts versus Lindsay Clancy is finished. However, we do know at the heart of this, Cora, Dawson, and Callan are gone. That fact has never been seriously disputed in this trial, which I thought was weird because I think that means more than somebody's mental health, because three young kiddos are gone, and I think that should be the focal point of this entire trial. She killed her kids. I think we just need to be honest. And the question this jury has actually been asked to decide is much narrower, which was Lindsay Clancy, criminally responsible when she did it? And after watching how these 21 days unfolded, there is something important I think that needs to be said. Neither side really walked through this courtroom untouched. The prosecution, landed punches. The defense landed punches. The prosecution occasionally strengthened the defense's arguments with its own witnesses, and the defense occasionally, handled the prosecution ammunition. And by the end, practically everyone agreed on one thing: something was profoundly wrong with Lindsay Clancy. But the disagreement is over, and what that something meant under Massachusetts law is something else entirely. And I think the prosecution really began with perhaps the most emotionally powerful witness available, which is Patrick Clancy. And to be honest, Patrick was an unusual prosecution witness because portions of his testimony really helped both sides. Patrick described January 24th of 2023 as essentially one of Lindsay's better days. He left the house, he went to CBS, he picked up dinner, he came home. And then in a moment, everything changed in an instant. That timeline really mattered tremendously to the Commonwealth. Lindsay had suggested the errands, and people who interacted with her around that period did not describe someone outwardly detached from reality. The prosecution's eventual theory was obvious. She created an opportunity to be alone with the children. That's strong evidence for the Commonwealth, but Patrick's testimony also created a serious problem for that same Commonwealth. Because he didn't describe months of a completely mentally healthy woman suddenly deciding to kill her children. He described a wife who had been struggling with anxiety, insomnia, suicidal thoughts, psychiatric treatment, medication after medication, a hospitalization at McLean, and approximately a month before the killings, Patrick knew Lindsay had disclosed thoughts concerning harm coming to the children. Nobody told Patrick that his children couldn't be safely left alone with their mother, and I really think that matters. He also testified about what Lindsay said after the killings, that she heard her voice telling her she had to act. So the prosecution's first major witness gave them evidence of apparent normalcy and opportunity. But he simultaneously gave the defense evidence of a documented psychiatric deterioration before anybody died. I think that's going to become a recurring theme in this trial, especially tomorrow with the closing arguments. And I thought it was amazing that, the Commonwealth did their homework, but they really brought in witnesses connected to CVS and 3B Restaurant. They described apparently ordinary interactions. Lindsay could communicate when she made the food order, as well as talking to the general manager about the Pedialyte that, Cora needed. She could make requests and she could function. And from the prosecution's perspective, I think that was really important. They wanted the jury asking, is if this woman was supposedly disconnected from reality, why was she capable of functioning normally immediately beforehand? I think that's a really legitimate prosecution argument, but I think there's a weakness. Their defense didn't have to prove that Lindsay was incoherent every minute of every day. The defense's position was that she suffered from a serious psychiatric illness and ultimately psychosis. And testimony later in that trial established that psychosis isn't necessarily synonymous with being incapable of performing ordinary tasks. So I think these witnesses helped establish functioning. They did not by themselves, though, establish criminal responsibility based on the testimony and the evidence. I think that's a really important distinction. And then I think one of the hardest testimony pieces in this entire case was the first responders, the paramedics, the emergency doctors, the ME, the medical examiner, the forensic personnel. The jury heard how Patrick discovered his children. They heard about the exercise bands, attempts at CPR, the ligature injuries, the asphyxia, and the desperate attempts to save Callan. Um, and they heard about Lindsay's own injuries, following her fall from the second story window. For the prosecution, the physical evidence established something extremely important. These weren't like instantaneous actions. There was a sequence. There was three kids with a method and multiple actions, and eventually the prosecution's psychiatric experts could return to that sequence and argue sequence requires decisions. The defense, however, gained something from Lindsay's injuries. This was not somebody who made a token gesture and then simply waited for the police. Like, she went through a second story window and sustained catastrophic injuries, including spinal damage that left her paralyzed. That doesn't prove insanity, but it certainly gives the defense evidence supporting the proposition that what happened that night included an extremely serious suicide attempt. Um, and I think that another thing is, like, I don't think the toxology report didn't really help either side get a knockout either. The jury did hear from the prosecution and the defense about her medications. And I think the toxology evidence confirms psychiatric medications were present. Um, but the levels did not establish some simple poisoning explanation where a toxic concentration alone really explained everything that happened. And I really think that's where expectations really surrounding this case collided with the evidence. Like, you heard the phrase in the proceedings that she was over medicated, but legally and medically, saying somebody had been prescribed numerous psychiatric medications is not the same thing as proving those medications cause legal insanity. Um, I think the defense, therefore, had to do something a lot more sophisticated. They had to show a trajectory of medication, sleep deprivation, anxiety, depression, possible bipolar disorder, deterioration, and eventually psychosis. The Commonwealth, meanwhile, could say, the toxicology report doesn't prove the medications really made her kill anyone. And I don't think neither side got a knockout from the crime lab with that toxicology report. Um, However, I think the medical witnesses on the prosecution side really created a problem for the defense. I think it's one of the Commonwealth's most strongest testimony in this trial. Lindsay Clancy had been receiving psychiatric care, and the people treating her weren't documenting obvious psychosis. And the people treating her weren't, just like Dr. Jennifer Tufts treating Lindsay through numerous telehealth appointments between September 22nd and January 23rd of 2023. And January 23rd is the day before the killings, and Tufts testified that she did not observe psychosis. That's powerful prosecution evidence. Because it's literally to the day before, this all went down. But if this defense says Lindsay was descending into postpartum psychosis, the Commonwealth then gets to ask, why wasn't her treating psychiatrist seeing that? Other clinicians simply did not document active psychosis, mania, or delusions during their interactions. And records indicated Lindsay sometimes denied suicidal or homicidal intent or plans. I think that's one of the biggest weaknesses in the defense case. Um, that contemporaneous medical records um, don't neatly say she is psychotic and hearing a voice commanding her to murder her children. Um, they don't say that. And we cannot rewrite those records because we know what happened later. But I think then the defense really gets something important with the medical testimony. It wasn't favorable to completely either to the prosecution, because Lindsay was seeking help repeatedly. Um, she was talking about insomnia. She had anxiety, depression, medication problems, suicidal thoughts. She voluntarily entered McLean Hospital. Her medication regimen kept changing. And psychiatric nurse practitioner Rebecca Gelada eventually evaluated whether Lindsay might have bipolar spectrum disorder or a mixed manic state because she could sleep very little without experiencing expected fatigue. And here's where I think something really matters. Gelada described Lindsay's state as actively participating in treatment. She worried about medication dependence. She wasn't characterized as somebody simply trying to obtain drugs, which is a really good thing because that could almost prove Munchausen's. Um, so the defense really had documentation of psychiatric distress that existed before the crime. I think it's extremely different from a defendant developing an insanity narrative only after being arrested. Um, I think this is another area where both sides really found ammunition with the digital evidence when the Commonwealth introduced internet searches and phone evidence. There were searches concerning suicide, psychiatric meds, mental health conditions, and there was a particularly disturbing search made days before the killings concerning treating a sociopath. Um, I think the prosecution wants that evidence viewed through the lens of planning and consciousness. But cross examination also exposed something else. Um, there were searches about postpartum depression and medication side effects, withdrawal, mental health treatment, and ordinary parenting matters. Um, so, I have to ask, what does the digital evidence prove? I think it proves that Lindsay was researching her mental condition. It proves she was concerned about psychiatric symptoms. Um, it proves suicidal thinking was a part of the story. Um, what it doesn't do cleanly is tell us why she ultimately killed her children. Like, I think that's one of the biggest things that I think I'd like to know. Um, just from being a father, I think it's really disturbing. This whole case is disturbing, and I mean, I don't know, but I don't think this evidence is not a knockout. And I think this is where the defense really started gaining serious footing is with when their family took the stand, especially Lindsay's mother Paula Musgrove, and her sister Allison Ogaza, her former mother-in-law Susan Clancy. Like they described deterioration with anxiety, paranoia, insomnia, suicide behaviors, suicidality, um, medication problems, and a woman they remembered as a loving mother becoming increasingly unlike herself. And most importantly, Lindsay's mother testified it's about something Lindsay disclosed in December of 2022, which were thoughts of harming the children. And that happened before January 24th of 2023. Um, I think it's enormously important for the defense because it gives a psychiatric deterioration a contemptuous history. But here's, I think, where the prosecution really got its opening. If the family genuinely believed Lindsay presented immediate danger to the children, like, my question is, why wasn't she committed and why weren't the children removed from her care? Um, why did the family members continue allowing her to be around them? I think it was a fair cross examination point. The defense's answer essentially is that they didn't understand the danger, and unfortunately, we now know what they didn't know then. Which I think that the kids should have been removed from the home long before any of this. I think if the mandated reporters would have done their job with all these medications and depression and see that there was so many supports, but the children were in immediate danger because of her behaviors, I think all this could have been avoided and the kids might be alive today. Um, I know it's pretty heavy-handed for me to say that, but I think when you have a woman that has this many issues and has been committed, I think it warrants like civil service or some kind of social service action to monitor the family and to be involved at this point. Because I know in Pennsylvania that would have happened, and I can't believe in Massachusetts it didn't happen. But the case at this point, finally reaches the central psychiatric battle with Dr. Donald Condi, Dr. Paul Zazel, and Dr. Philip Resnick. These witnesses really gave the defense the professional framework it really needed. Their argument really became bipolar disorder plus postpartum psychosis. Resnick's testimony was particularly important because he described what Lindsay reported as a command hallucination, which is a male voice, a command to kill the children. And according to the defense theory, Lindsay experienced something beyond simply hearing words. She described here feeling as though an outside force had taken over her body, like a dreamlike state, a loss of control. Um, and I think that directly addresses one of the critical legal questions. I think even if Lindsay understood killing was wrong, did mental disease or defect leave her without substantial capacity to conform her conduct to the requirements of the law? That's where I think the defense really got to be the strongest, the case itself. They don't necessarily need every juror believing Lindsay thought murder was morally acceptable. They just need reasonable doubt concerning criminal responsibility. And I think another significant piece of defense evidence popped up with the psychological testing when it did not indicate malingering or symptom exaggeration. And it doesn't prove the command hallucination happened exactly as Lindsay had described it, but it makes a simplistic prosecution argument that she simply fabricated mental illness considerably harder. Um, and that's a distinction that we need to maintain. No evidence of malingering does not equal every statement Lindsay Clancy made is objectively true. It just means testing didn't support the conclusion that she was intentionally faking or exaggerating symptoms. And then, one of the biggest contradictions, I think, is hospital chaplain Sheila Kavanaugh. She had extensive interactions with Lindsay after the killing. She testified that Lindsay eventually discussed a male voice commanding her to do that. That helps the defense, I think, because it proves another person who says Lindsay disclosed the voice. Then the Commonwealth went straight for the records. Kavanaugh's written hospital notes didn't document that command voice. problem. That means she might have been coached, and the prosecution was really right, in my opinion, to emphasize that. If the voice was this central to Lindsay's experience, why isn't it in the contemporary and amorous documentation? Especially with Kavanaugh's response, it was essentially the chaplain notes aren't psychiatric transcripts, and she wasn't there conducting forensic interviews. That's all. I think that's also reasonable. Um, so once again, the jury has really two interpretations. The Commonwealth says the story isn't documented when we expect it to be. The defense says absence from a chaplain's notes isn't proof the conversation never happened. I think both are legitimate arguments. And then after the defense rested, prosecutors called the rebuttal experts. And this is where I think the prosecution regained substantial ground. Um, Dr. Avram Mack rejected the defense's ultimate conclusion. His diagnosis centered on major depression rather than postpartum psychosis, and he concluded Lindsay retained criminal responsibility. And then came Dr. Kirk Heilbrunn. He diagnosed bipolar 2 disorder and severe depression. And I think we need to notice something important. The prosecution's own expert wasn't telling the jury nothing was wrong with her. Instead, the Commonwealth developed a much more sophisticated story. In theory, Heilbrunn proposed something closer to an altruistic filicide suicide explanation. In simplified terms, Lindsay was suicidal. She believed her children would suffer without her. She killed them before attempting to kill herself. If the jury accepts that explanation, the Commonwealth can acknowledge severe mental illness while still arguing she remained criminally responsible. Um, that may be right there the prosecution's strongest conceptual argument of the entire trial. Um, I think Heilbrunn really helped the Commonwealth when he testified that Lindsay retained awareness of the illegality of her killing her kids. That goes directly to criminal responsibility. Um, and the Commonwealth could combine that opinion with evidence of sequencing. You know, Patrick leaves. There's 3 children. There are exercise bans. There's children that are killed individually. Um, and then suicide attempt afterward. That can be argued as purposeful conduct. Um, and then came the religious testimony. Questions involving Catholic beliefs, mortal sin, and whether Lindsay believed she and the children could be reunited in heaven entered the testimony. Defense counsel moved for a mistrial. Judge Sullivan denied the mistrial, but he struck the testimony from the record, characterized the subject as inappropriate, and instructed the jurors not to consider it. That is not a small courtroom moment. When the judge strikes testimony from the record from your own expert witness and sends the jury home early after the defense accuses you of misconduct, you have lost footing. The jury is legally required to disregard it, and that's exactly what we should do when analyzing the evidence. Um, and I think the Commonwealth, I think, really redeemed themselves with Dr. Gregory Sadoff and the command voice. Um, and Sadoff attacked perhaps the most important component of the defense case, which is the voice. His point was fascinating. According to Lindsay's account, the voice commanded her to kill, but prosecutors broke the alleged command down. They asked, did the voice tell her where? He responded by saying no. The prosecution asked Dr. Sahoff, they asked, did it tell her how? He said no. And the prosecution asked the doctor, did it select the weapon? He said no. The prosecution asked, did it determine the order? He said no. Did it tell her how to kill herself? Dr. Saitoff said no. Saitoff essentially argued, if the voice only supplied the general command, Lindsay herself still had to make a series of decisions necessary to carry it out. And he questioned another detail. Why did the voice apparently stop once the killings were completed? From his clinical perspective, accomplishing what a hallucinated voice commands isn't ordinarily some automatic cure for hallucinations. That, in my opinion, and even in court testimony, is a very strong prosecution testimony because it attacks the mechanism of the defense theory rather than merely saying, I do not believe her. And then Reddington cross-examines him. I think the defense attacks Sacktoff's experience specifically with postpartum psychiatric illness. They emphasize that he evaluated Lindsay years after the killings. They highlighted the limitations inherent in reconstructing somebody's mental condition more than 3 years later. They then returned to Lindsay's sleep deprivation and her treatment history and the medication concerns, and then something extraordinary happened. at the end of this trial. Reddington confronted the Commonwealth's own witness with the prosecution's characterization of Lindsay's condition, and Satoff acknowledged that the description minimized what Lindsay had been going through. Like, think about where we started. The prosecution wanted to prove criminal responsibility. Their final witness still wasn't saying nothing was wrong with Lindsay Clancy. Quite the opposite. The dispute remained over whether the illness crossed the legal threshold necessary to eliminate criminal responsibility. That's exactly where 21 days of evidence now has landed. And after 21 days, here are things that appear remarkably consistent across the evidence. Lindsay Clancy was experiencing serious psychiatric problems before January 24th of 2023. She had severe sleep problems. She did seek professional help. She did undergo numerous medication changes. She experienced depression and anxiety, as well as suicidal thinking. She voluntarily sought hospitalization. Her family observed significant changes. However, she killed her kids. She then attempted to unalive herself and sustained catastrophic injuries that left her paralyzed for the rest of her life. But virtually nobody involved in this case is arguing that she was psychiatrically healthy. Those are really the areas where the evidence largely converges. And I really want to talk about the inconsistencies on both sides of the fence. These don't really fit neatly. Yeah, especially the command voice. The defense says it was real and crucial, but contemporaneous medical documentation before the killing wasn't clearly documented. Some witnesses later say Lindsay disclosed it. Some written records don't even mention these disclosures. And the prosecution experts question whether the characteristics of the alleged hallucination made clinical sense. That is a major factual dispute. And then we have psychosis. Defense experts say postpartum psychosis. Prosecution experts disagree. Yet even prosecution experts diagnose severe psychiatric illness. So the argument isn't really sick versus healthy, it's how sick, in what way, and in what capacity did she retain on January 24th. And she had apparent normalcy. She could communicate with CVS. She could arrange for food to be ordered and to be prepared and picked up. She could perform ordinary tasks. But evidence also established that people suffering from serious psychiatric illness can sometimes function normally. So neither side gets to claim ordinary functioning automatically. And it doesn't automatically prove or disprove psychosis. Also the timing. The prosecution sees Patrick's errand as opportunity and possible planning. I think the defense sees an ordinary family errand occurring during a catastrophic psychiatric break. They're the same timeline, but they have a completely different interpretation. And where I think the prosecution was strongest is the Commonwealth was strongest when it stopped trying to prove Lindsay wasn't mentally ill. That was never going to work. The medical history was simply just too extensive. Their strongest argument really became mental illness is not automatically legal insanity. They had treating providers who did not observe psychosis. They had contemporaneous records without command hallucinations. They have evidence of apparently organized behavior, along with digital evidence, and the sequence of 3 separate killings. And they had experts willing to say Lindsay retained awareness and control. And Satoff's dissection of the alleged voice was particularly effective, in my opinion. However, I think the prosecution was the weakest. Was the sheer amount of documented psychiatric deterioration that predates the killings. Like, they can't explain this case as perfectly healthy woman suddenly murders 3 kids. Their own experts acknowledge serious mental illness. Like, the family described deterioration. The treatment history is real. The hospitalization is real. The medication changes are real. The insomnia is real. The suicidal thinking is real. And once lack of criminal responsibility is properly raised, the Commonwealth carries the burden of proving criminal responsibility beyond a reasonable doubt. That is an enormous hurdle in a case containing this much psychiatric evidence. And also, the religious questioning also created an unnecessary courtroom problem that resulted in testimony being struck from the record. And I think the defense also was strongest in chronology. Lindsay didn't really start struggling until after she was charged. The record documents psychiatric problems beforehand, months beforehand. The family saw him. Patrick saw him. Doctors treated him. Medication was prescribed. McLean admitted her. She talked about suicidal thoughts. She disclosed disturbing thoughts involving the kids and hurting the kids. I think that's powerful because it makes it impossible to dismiss the entire psychiatric history as a post-crime intervention or invention. Um, and the defense experts then connected the history to bipolar disorder and postpartum psychosis. Um, and psychological testing reportedly found no evidence of malingering, which basically means there's no Munchausen. She's not doing this for attention. Um, However, I think the defense's biggest vulnerability is also obvious. Where is the contemporaneous documentation of the command hallucination? If the male voice is the centerpiece of the explanation for the killings, the prosecution has every right to ask why treating providers weren't documenting it beforehand. The defense also has to explain purposeful looking behavior. 3 children were not killed simultaneously. There were multiple steps with multiple decisions. And prosecutors will argue that Lindsay's behavior surrounding the killings demonstrates organization and control. The defense simply cannot answer every difficult fact with psychosis. They have to persuade the jury that the psychiatric disease affecting Lindsay's legal capacity at the precise time where these acts occurred. I think the biggest thing that both sides proved is after 21 days, here's what I think this trial established more clearly than anything else. Um, this case is substantially more complicated than the internet ever made it. I think this case is going to be discussed in law schools for the next 50 years, or maybe more. If somebody really tells you she was obviously completely sane, or the evidence doesn't make it that simple, or if somebody tells you postpartum psychosis has unquestionably been proven and therefore she's automatically not criminally responsible, um, the evidence doesn't make that simple either. There are legitimate weaknesses in both cases and strengths in both cases. There are contradictions and corroborations. There are records that help the Commonwealth. There are records that help the defense. And there are witnesses called by one side whose testimony occasionally benefited the other. So my assessment here at the Rant Press, after 21 days of testimony, I asked, who gained the most ground? The defense did establish mental illness. I don't think the Commonwealth successfully erased that, but that's not what the Commonwealth legally needed to prove. The prosecution established a very credible argument for retained capacity despite mental illness. That's a distinction this case turns on, and that means tomorrow's argument shouldn't really be, was Lindsay Clancy sick? The evidence, overwhelmingly established serious psychiatric illness. The question is, did that mental disease or defect deprive her of substantial capacity to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law? That's the question tomorrow that the jury's going to have to answer when they deliberate. Not TikTok or Facebook, and not me, not you. 12 jurors. And the Commonwealth has to satisfy its burden beyond a reasonable doubt. And I don't think we're going to get a verdict tomorrow. I think statistically we'll probably get one on Friday, maybe Monday, maybe Tuesday. I'd say my highest likelihood is probably going to be Friday, at like 50%. Monday's probably 15%. Tomorrow's about 10%. I really think if the jury starts asking for case notes and witness testimony, I don't know. It's it could be a hung jury. They could be deadlocked. I don't know. All I do know is that Cora Clancy was 5, Dawson was 3, Callan was 8 months old. Whatever verdict eventually appears on that piece of paper, those 3 names cannot become footnotes in history underneath their mother's name. They are the victims at the center of this case. They should not be forgotten. And I think the hate on social media has got to stop, and we need to come together and remember the 3 kids that lost their life that night. I think, but respecting those children really also means respecting the process being used to determine what happened. That means looking at uncomfortable evidence. It means acknowledging evidence that hurts the side you think should win. It means understanding that mental illness and criminal responsibility aren't necessarily the same question. And it means refusing to turn a courtroom into a comment section. I think for 21 days, the Commonwealth and the defense have been fighting over one question. What was really happening inside Lindsay Clancy's mind on January 24th of 2023? The Commonwealth says she was severely mentally ill but responsible. The defense says she was severely mentally ill and capable, and she was incapable of conforming her behavior to the law. Same woman, same psychiatric history, same horrific night, but 2 radically different legal interpretations. Now the witnesses are finished. The evidence is in. Closing arguments are next. And then this case leaves the lawyer's hands. It goes to 12 jurors. And each closing arguments gets an hour. I think Mr. Reddington said he was going to get 30 minutes. Only going to take 30 minutes. The prosecution is going to take the full hour. However, whatever they decide, the Rant Press will be there to break down the verdict against the evidence and against the internet's opinion. I'm Tony. This is the Rant Press. Read the evidence, question the internet narrative, and respect the victims. And as always, embrace the rant. Read it and Rant is out.